Welcome, everyone. Good morning, afternoon, depending on where you're joining us from. My name is Zachary. I'm a senior associate in our Federal Labor and Employment Group. I'm in the Rochester office of Tully Rinckey, mostly practice in the EEOC, the Merit Systems Protection Board, the Office of Special Counsel. You'll see a little bio here taken from our website. So today we're going to be talking about reasonable accommodations. You can go to the next slide. We're going to be talking about the Rehabilitation Act, the ADA, the Americans with Disability Act, covering what is a reasonable accommodation, what is the interactive process that's required, and what is required of both the employee and the employer. And then also some steps to follow if the reasonable accommodation has been denied. So for the Rehabilitation Act, this is an act passed in 1973. It did expand responsibilities and obligations of employers to their disabled employees, and it does require some affirmative action on the part of the employer, especially in the context of reasonable accommodations. So the Rehabilitation Act prohibits discrimination on the basis of disability in programs conducted by federal agencies, those receiving financial assistance from the federal government, in federal employment, and employment practices of federal contractors. Under the Rehabilitation Act, which is called the Rehab Act, an employee may qualify as disabled if the employee has a physical or mental impairment that substantially limits one or more of their major life activities. And what is a major life activity? It's a wide range of things. We've listed a few here, can include working, sitting, lifting things, sleeping, walking, concentrating. There are very long lists, and they apply specifically to each impairment. An employee may also be considered disabled under the Rehab Act if they have a record of such an impairment or if they're regarded as having such an impairment. A record is a history of essentially once suffering from a physical or mental impairment that substantially limited one of those major life activities. And this is even if the employee has fully recovered from the disabling condition. Next slide. And then regarded as can be if the supervisor or any other agency employee, member of management, human resources, believes that the person has a mental or physical impairment that substantially limits one or more major life activities, even if that belief is mistaken. So an example of being regarded as having a disability is if someone has difficulty hearing in the office, but is not deaf or hard of hearing, and the manager or supervisor erroneously believes that the person is deaf. Under this circumstance, they would be able to file a claim with the EEO office alleging disability discrimination because that employer has erroneously regarded them as having a disability. Now we have the ADA. The ADA was passed in 1990. Essentially, it expanded the Civil Rights Act of 1964 and the Rehab Act with a particular focus on disability discrimination, reasonable accommodations, and accessibility for disabled people. Title I prohibits employers from discriminating against people with disabilities in employment-related activities. This includes the recruitment process through hiring all the way to pay and benefits. Covered employers that are covered by the ADA can be state or government employers with at least 15 employees, and all employment agencies, labor organizations, and joint labor management committees, regardless of how many employees they have. Employees that are covered by the ADA, again, are those with disabilities that are covered to perform the essential functions of their position. And you must be able to do this with or without an accommodation. We'll get to that in a second. Employers might grant leave to an employee requesting an accommodation in order to allow that employee comparable resources or accessibility to a similarly situated employee that does not have a disability. And a few definitions from the ADA that are important. An individual with a disability, just like the Rehab Act, is one with a physical or mental impairment that substantially limits one or more of those major life activities. An individual having a record of such an impairment or being regarded as having such an impairment. The ADA does not require employers to provide leave for medical or disability purposes. Those are covered by other laws, including FMLA. Those might overlap with the ADA in some way. The ADA does require, though, reasonable accommodations for qualified employees with disabilities to perform their essential functions or their role, or to benefit from the same opportunities that other coworkers have that do not have a disability. And those are those similarly situated coworkers. Accommodations always depend on the individual circumstances of the employee and are generally granted unless doing so would result in an undue hardship for the employer. And we'll cover that in a little bit too. So what is a reasonable accommodation? An accommodation is one that's provided to a qualified person with a disability that accommodates a known physical or mental limitation. And let's break that down a little bit. The agency is not required to provide the employee precisely what they have requested, but must provide an accommodation that's responsive to and tailored to a specific disability. The request has to be related to that limitation that renders that person disabled. And only qualified persons with a disability are entitled to a reasonable accommodation. We've hammered this home with the Rehab Act and the ADA. And again, to be qualified, you have to show that with or without the reasonable accommodation, that you can perform the essential functions of the position. So in order to request a reasonable accommodation, you have to be able to perform those functions despite having the accommodation whatsoever. If you cannot perform those essential functions, you're not entitled to a reasonable accommodation under the Rehab Act. Some examples of reasonable accommodations, and this is by no means an exhaustive list, but a few examples. Telework, which has become much more common nowadays in the years following the pandemic. Telework requests have gone through the roof. Agencies have been handling them in different ways, but telework has become a much more popular accommodation for disabled folks. Reducing working hours, part-time or modified work schedules. I think that one's fairly common as well. Access to assistive technology. This is very important. That could be wheelchairs, modified computer screens, other accessibility equipment that can be provided inside the office or at home. Additional training, qualified readers, adjustments to modifications, to examinations, that's in the hiring process. Personal assistance services, which is a very large one and fairly difficult to get. And then finally, reassignment to a vacant position. And this is known as the accommodation of last resort, and we'll get to that in a little bit as well. So what are the basic requirements for requesting an in-office reasonable accommodation? First and foremost, you have to follow the procedures for the individual employer or agency for requesting those reasonable accommodations. They vary across the agencies and employers a lot, so it's important to know the standard operating procedure or the process to get through the reasonable accommodation. The important thing to note here, though, is that no magic words are necessary to start this process. You don't have to say the words reasonable accommodation in order to be guaranteed those protections. This could be a simple conversation with a supervisor, a member of management, a member of human resources that would qualify as requesting a reasonable accommodation, so long as you identify that limitations do exist and certain accommodations might be needed. The request at this point does not need to be very specific. It just needs to identify those limitations, and it doesn't need to list the specific disability at this time. And you don't need to disclose that disability to your supervisor. That will come later in the process. It is a good idea at this point to make your request in writing, though. essentially creating a record of your request so that it's not just your word against the member of management or the supervisor. This could be done just by a simple email that will create a record, or by a letter from either you, your doctor, or an attorney. This triggers the agency's obligation to engage in what we call the interactive process. And what is the interactive process? It's a collaborative effort between the employer and the employee to determine if the employee is able to perform the required job functions and if the employer can make a reasonable accommodation for the employee's disability or limitation. So first, have to establish that you're a qualified person with a disability. That means meeting this requirement of having a mental or physical impairment that substantially limits one or more of the major life activities, and that you can still perform the essential functions of the position with or without that reasonable accommodation. Second, the employer is obligated to now engage with the employee, with a supervisor and other relevant individuals. It could be a human resources individual, a doctor. Sometimes agencies hire their own experts to do examinations or evaluations, and this is to determine possible accommodations. So first, what will happen in this meeting or engagement is to identify the nature of the impairment. And again, you do not have to disclose the disability per se at this early juncture, just what the impairment may be. And then the employer has to take affirmative steps to assist you in identifying an effective accommodation, including facilitating any necessary evaluations or conversations with their committees or experts. The direct supervisor is involved in the process, but is not privy to your protected medical documentation or your particular disability. Those are protected by HIPAA. Slide. And so to determine whether or not this accommodation might be reasonable, the employee might look to accommodations that have been granted to similarly situated employees that may have a disability, a similar disability, or one that's not. For example, if a similarly situated employee has been given telework and the employee is requesting telework for a disability, that might be something that plays into their consideration. Asking the supervisor what accommodation they believe is reasonable, consulting with HR or the EEO office to determine what accommodations might be reasonable under the circumstances. One really important thing to note here, and something that comes up a lot in litigation and in EEO complaints, is that accommodations cannot be used to reduce productivity requirements. Those might be statistics or standards in your performance evaluations. An accommodation can't be used to reduce those. This slide is really important, and we've provided it here for those who are not familiar with JAN. That is the Job Accommodation Network. Essentially, this is a free toolkit. It's completely free. It's available to both employers and employees. There's a ton of resources on here. There's trainings that employees and employers can take. There's policies that are available to both employers and employees. And then we've also just provided a little screenshot here of SOAR, which is the Searchable Online Accommodation Resource. And this is within JAN. It's on the JAN website. And the website, by the way, is askjan.org. SOAR, you can type in your particular impairment, work-related function, disability, whatever it may be, a keyword, and then it will spit out a list of accommodations that might be available to you or might be considered reasonable under the circumstances. So you can see there's a list of popular searches, includes diabetes, fibromyalgia, learning disabilities, those types of things. So if you don't know exactly what accommodation to request or are kind of at a loss as to where to seek this information, JAN should be your first line of defense. And it's a great resource. We use it in our practice. We encourage the agencies to use it in discussing reasonable accommodations. And a lot of agency reasonable accommodation committees or specialists look to this first to determine whether a particular accommodation is available or reasonable. Next slide. The third thing in the interactive process is following the procedures for requesting accommodations. This is where the SOP kind of comes into play. Cooperating with the reasonable accommodation specialist or committee or the assessment team. And these will be members of human resources that are not directly connected with your supervisor or management chain, but you can provide medical documentation and private information to. And that does include providing that medical documentation when it is requested. We always advised to submit within a reasonable amount of time. Obviously, agencies and specialists understand that delays happen with obtaining records with your doctors. Physicians' offices are usually very busy, can take weeks to get those records. But it's important to know that a delay in providing the information can be attributable to the employee if a complaint arises later that alleges that the process did not happen within a reasonable amount of time. Responding to inquiries regarding the disability, if there's a request for information or specific supplementation that they're requesting, doing that within a reasonable time is important. And then working with your employer to identify those reasonable accommodations. That might be a conversation with your supervisor or the reasonable accommodation specialist or committee, talking about Jan, looking at it together, those things to help you move through those resources. And then also the doctor providing the employer with diagnosis and prognosis. These are very important things for the doctor to provide. It can't be a one-line letter from the doctor saying that you need an accommodation. It has to have a description of the disability. There is some specificity requirement for the disability description. The probable length of the condition, that's the prognosis, and then why this particular accommodation is necessary and will help with the limitation. And then finally, the employer has to determine whether or not this accommodation would pose an undue hardship. And this is a legal term of art. An undue hardship is very difficult to prove for most agencies due to the range of qualifying impairments and possible accommodations. Jan is a very good example of that. There are a ton of possible accommodations that could be considered reasonable. An undue hardship can be considered a significant difficulty or expense. And this is all related to that reasonableness inquiry, the reasonableness of that accommodation. They can also consider a disruption to the workplace and whether or not it impacts the efficiency of the service. And then at the end of this interactive process with the supervisor, the human resources is involved, the reasonable accommodation specialist or committee, the employer has to either grant the accommodation as it's requested or reject it after due consideration, and then initiate a discussion with the employee of other possible accommodations. It doesn't end there. Some other paths that the agency can take include identifying additional information necessary to complete the request. This could be additional medical documentation if the letter from the doctor is insufficient, if it's that one-liner like we talked about before. It needs to be specific, and they can ask for additional information to complete the request. And the agency can also consult with experts to determine the necessity of the accommodation for the specific impairment, especially where it's very specialized or accessibility related. They may consult with experts, do an independent evaluation, and determine whether or not that is reasonable. And then another thing the agency can do, but is not required to do, is consider a temporary accommodation. This might be while the agency is researching a permanent accommodation solution. It could be even as a way of testing whether or not an accommodation would be effective or reasonable, especially where the agency is unsure. It can also be where the medical impairment is only really temporary, but it is sufficiently severe to be covered under the ADA or Rehab Act. If the agency can only provide an accommodation temporarily, they usually will do this, but they know that an undue hardship could arise in the future and limit that reasonable accommodation in time for a specific period of time. And lastly, the agency can consider reassignment to a new position that's compatible with the accommodation And in this, they'll most likely request a resume that will have your education and relevant work experience and other skills that you may have. This is an accommodation of last resort. This is essentially a final opportunity for the employee to retain employment with the agency or employer. A reassignment would be a non-competitive permanent transfer to a vacant funded position at the same exact grade level as what they were before. There's no obligation on the agency's part to search for a higher graded position or to create an entirely new position for the employee. They would defer to the employee's choice of position if multiple are available. And usually what would happen is they present the different choices and allow the employee to choose. And this is an example from Jan of an accommodation approval form. This will look different for every employer, every agency, but it has the basic information that is on an accommodation approval. It might be in the form of a letter, but it will contain this information. And you can see when the accommodation was approved, how long it will be implemented, whether or not it's on a trial basis, whether or not there's been equipment ordered and who's going to do that, whether or not there's training, other steps for management or your supervisor. And this will be signed by both the employer and the employee so that everyone is aware of what the accommodation is. And then, so the extent of the agency's obligations to provide these accommodations, the agency is only required to provide an in-office reasonable accommodation to the extent that the agency, either the supervisor or the appropriate agency official, is aware of the person's disability or limitation and also aware of the person's request for a reasonable accommodation. Again, it's important to note that you don't need to use magic words here, but use common sense and decide whether or not that person is aware of the disability. They might be aware of that explicitly or implied through interactions with you. It is extremely important at this juncture to precisely identify the accommodation that you're requesting and ensure that they're aware of the request. Again, do this in writing if possible, and also the basis for the request. If the employee presents a direct threat or significant risk of substantial harm to the health and safety of the individual or others that cannot be eliminated or reduced by the accommodation, then at that point, the agency is not required to provide a reasonable accommodation. Also, the agency is not required to provide an accommodation the efficacy of which is unreasonably disproportionate to its costs. For example, a top-of-the-line electric scooter or a mechanical wheelchair, they're not required to provide you the top of the line. It does not also have to provide the exact requested accommodation that's requested in the form or with the employee, only one that's reasonable. So the agency and the employee might have a difference of opinion on what is reasonable under the circumstances. And along the process, if the reasonable accommodation specifically requested is denied, if less than effective or partial accommodation is provided, at that point, the employee can file a complaint with the EEO office if they believe that the request was unfairly denied under the Rehab Act. So if you do get a denial or a partial acceptance of a reasonable accommodation, it's very important to take steps to protect your rights under the Rehab Act or the ADA. This includes contacting your EEO counselor to initiate an informal complaint, and this will be a failure to accommodate disability discrimination complaint, providing the agency with any additional information that may support the request, especially where they've requested additional information or supplementation of any kind, and then considering whether the proposed alternative, if one is offered, if a partial accommodation is offered, is actually reasonable or effective in your circumstances. At this point, we'd advise you to contact Experienced Employment Counsel, set up a consultation with us, if you are denied a reasonable accommodation. There are very important deadlines and administrative and procedural issues, including exhaustion, that must be addressed at this early stage in the process. For example, 45 days is the deadline for contacting an EEO counselor and initiating that informal process. This is from the date of the denial of the reasonable accommodation or the date that you reasonably suspect that the accommodation may be denied. And that could be just from a conversation with your supervisor. It could be from an email. It could be from a discussion with the reasonable accommodation specialist. But 45 days is the operating time period, just as with any EEO complaint. The employee must carefully construct the language of the formal complaint to make sure that these failure to accommodate claims and any other potential claims that might go along with it are administratively exhausted with the EEO process. It's important at this point to obtain advice what to do in face of a competing accommodation offer, especially again, discussing whether or not that proposed alternative accommodation is reasonable or effective in your particular circumstances. So we can help you by counseling you on recognizing and preserving your claims for failure to accommodate. And this includes identifying your claims, what they are, by interviewing you, counseling you through difficult situations, either with the supervisor. For example, the supervisor is demanding private medical information or the specific disability, and that can only be discussed with human resources. Determining whether exceptions apply, such as undue hardship. Acquiring and developing evidence to prove your claims ultimately if you're going to move forward with the EEO process. We can also negotiate with the agency to settle the complaint at the informal stage. This includes evaluating whether or not your case may be strong or weak, depending on your particular circumstances, counseling you on the pros and cons of early resolution before the complaint goes to the formal process and the EEOC is involved, leveraging your case with the agency's attorney and representatives, and using all of the facts to your benefit. And then making sure that that settlement or that accommodation is in your best interest, and that it includes whether or not it's reasonable and effective and whether or not that actually applies to your circumstances. And then also protecting you in the event there is an agreement and the agency breaches that agreement. Most importantly, ensuring timeliness. This is the most important thing in the EEO process, because missing a deadline could result in your case being dismissed from the EEO process altogether, or significant harm to it where certain claims are dismissed and others survive. There are a lot of complex procedures and deadlines in the EEO process, so it's important to have counsel with you to navigate these things. And then also just leveling the playing field to prevent injustice. You don't want to get in a situation where the agency has a representative and you don't, and they're being unnecessarily aggressive in their defense. And then also recognizing those improper evidence requests, developing an accurate record for the EEO process and the complaint. So we have a couple questions that we've identified before the presentation started, and I think we've covered most of these, but I'll just run through them with a few reminders. So the first question is, can you raise a failure to accommodate issue at any point, or does it have to be right away? And the answer is it has to be within that 45 days of either the denial or of when you reasonably suspect the accommodation is going to be denied. This is not like if you're familiar with a hostile work environment harassment claim, where it can be a pattern and practice of hostile work environment harassment, and the most recent issue or allegation has to be within that 45 days. The failure to accommodate issue is a discrete issue from a hostile work environment harassment claim and must be raised in that 45 days. And then what are those appropriate steps to take if retaliated against for requesting reasonable accommodations? This is really important to initiate that EEO contact after you suspect that you've been retaliated against. Requesting reasonable accommodations is considered a protected EEO activity for the purposes of a reprisal complaint. So it's important to raise that early on in the process, in the informal process. And even if you're filing a complaint for a failure to accommodate, you can still be retaliated against for your engagement in that process and in the interactive process, and then also in the EEO process. So it's important to amend your complaint if you suspect reprisal as well. And then also, what should you do if your supervisor refuses to meet with you to discuss the need for reasonable accommodation requests? I would say, number one, make a record in writing. Make an email, send a letter, emails to human resources, however you need to do it. Make a record so that it's not their word against yours that this request has been made. Number two, retain counsel. At least engage with counsel to consult about the process, what your rights may be, and what actions to take. And it's a good idea to do this sooner rather than later, given that 45-day deadline. Who has access to the reasonable accommodation request? I think I addressed this a little earlier, but it's important to note that the supervisor themselves do not have access to the specific disability or the supporting medical documentation. A lot of supervisors will make requests, specific requests of this information of the employee, and they're not allowed to do that. The Reasonable Accommodation Committee, specialist, human resources, they have another person to handle this private protected information. So the supervisor will have access to what the request is and what the impairment is, what the limitation may be, and also what has been requested or approved through the process. Will I stay at my same pay grade if I request a reasonable accommodation for my position? Absolutely. The pay grade should not change at all. One thing that can be proposed is a change to your position, a change to your duties, a reassignment to a different position. But again, that reassignment is, number one, a accommodation of last resort, and number two, has to be at the same pay grade. Are employers required to provide temporary accommodations? And I think I addressed this as well. This can happen in a number of different situations. It is fairly common for an agency to do this. It will have a kind of a expiration date on the temporary accommodation, and this actually dovetails into the last question, which is whether the employer can rescind the accommodations. And this, so if there's a temporary accommodation, or if there's one that they know will pose an undue hardship later on, or would impact the efficiency of the service if it continued, the temporary accommodations can expire, and the agency can require you to kind of recertify your limitation, provide additional medical documentation, an update from your doctor, again, with that diagnosis and prognosis to determine whether or not that accommodation is still necessary, whether it's still reasonable, whether it's still effective. I think we've moved through all of those questions. If you have any other questions that I have not addressed in the presentation or in the Q&A at the very end, or if you have a question about your very specific circumstances, please contact us. We can set you up with a consultation. Contact our client relations department. We've listed a couple phone numbers here and email. Please get in contact with us, especially if you suspect that your accommodation would not be granted. And I think there is one additional question here. The question is, per CDC standards, I am at an increased risk of serious illness or death if I get COVID. Is this considered a disability under the ADA, and can I request reasonable accommodations? The answer is not a simple one, and this is something that's been an issue for the last couple years, especially in folks that, for example, are in a healthcare situation. COVID itself has been declared a disability under the ADA, and long COVID especially. So your increased risk of serious illness or death if you do contract COVID is not necessarily a disability in itself, but the underlying condition or impairment may be. So if you are immunocompromised, that might mean you have diabetes or another limitation or another disability that impacts your body's ability to resist or fight COVID. So the underlying limitation, the underlying disability would be the disability under the ADA. And absolutely, you can request accommodations for this purposes. We've had some good success with getting some accommodations for folks with this exact issue.